bill is House Bill 784 by Representative Richard. I think we have some of the judges here. Okay. I think we can hear it without him.
Thank you, Mr. Chairman. Members, I'm Bob Morrison with the Louisiana District Judges Association, and Judge Jerome Barbera, who is with the 17th Judicial District Court, is also here to explain the bill. You want to go?
Yeah. Mr. Chairman, members of the committee, I'm Jerry Barbera from Thibodeau District Judge, and the purpose of this bill is to protect the physical medium, the court reporters' tapes, compact disc, that are used to record proceedings in court. The court reporter has always traditionally been the reporting person to say what exactly happened in court. If somebody wants to know what happened in court, they can order a transcript from the court reporter. She prepares it, or he prepares it, types it up, certifies it, and then that's the official proceeding. A technical reading of the Public Records Act would suggest that the tape itself or the disc itself would be a public record. Purpose of the bill is to say that the court reporter's tapes, the physical medium, the thing that contains the recording, is not a public record. We have concerns already in court today because of people using cell phones to record audio and video. They show up on Facebook. They show up on other social media. Somebody could take a tape from a court reporter, doctor it up, take snippets out of it, excerpts from it. It could be posted. It's not a good thing. So the purpose is not to hide anything. The purpose is to say that the official transcript of what went on in court is what the court reporter prepares and certifies. And there's no need for anyone to get a tape, a disc, or a cassette. Bob?
I would just point out there are some instances, too, where in court a question is asked and a witness nods. I mean, we try to police that and say you have to answer out loud. Sometimes that doesn't happen. If somebody then tried to say, well, this particular fact wasn't proven because there's no response on this audio recording, where the court reporter, part of her duties or his duties are to, include like nodding affirmatively, for example. So we want the transcript to be the official record as provided by the court reporter to avoid any issues that disseminating the recording might make.
And there is an exception in the bill in the event that there's a disciplinary proceeding against anyone where this tape might be important. Well, then, of course, it does then become a public record if it's used in a disciplinary proceeding.
To the extent that perhaps there's a disciplinary proceeding against an attorney that was involved or a judge that was involved, and it involves a kind of a temperament issue. If somebody's yelling and screaming, that kind of thing, they could get the actual sound recording. So I think that's pretty much it, and we'll be glad to answer any questions.
Representative Miller.
Thank you, Mr. Chairman. Judge Morrison, in these type of situations, my understanding is it's almost like the property of the court reporter, and they're charged, they have to maintain, they're not paid typically to maintain these tapes. They almost have to keep it all stored at their own house at their own expense. Is that correct?
Well, that may vary from district to district, Representative Miller. In my district, the court itself, we do store those records. We're required to, and we actually have to get climate control many warehouses, but we pay the expense. The court reporter does not in our district.
And if there's a dispute as to a discrepancy over whether the transcript is accurate, then you're still subject. The court reporter's tapes are still subject to being subpoenaed in the court proceeding. Is that correct? They
have been in instances before. They could be used under a court order for a subpoena and recognized subpoena. This came out of someone asking just for free dissemination of one of these recordings, and our concern, as you would know from practicing law, is that you might have a bench conference with both lawyers not wanting to be that to be off. Well, they both do want it to be off the record, and it's picked up on the recording and that kind of thing. So the transcript needs to be the official record. That's the point of this.
And this would, I mean, a lot of times you go to the bench and maybe they turn the tape recorder off because it's supposed to be off the record, but sometimes that recorder is still on, and that's part of what you're trying to address here.
Yes, we in our district are now using digital technology, so it records onto a compact disc, and it just keeps running. And it, even though the sound system shut off for off the record bench conference or something like that, it still would get on the tape.
Okay. Thank you, Mr. Chairman. Thank you.
Okay. The board is clear. Representative, are there any cards? Okay. Technical amendment. Mr. Mahaffey will detail it.
Members, we have a technical amendment, and it involves changing the term certified official court reporter in the bill to read official court reporter. You'll see that on page 1 at lines 17 and 18, and then again on page 2 at line 11.
Okay. I'll go ahead and move to adopt the technical amendments. Is there any objection? Hearing none, the technical amendments are adopted. Representative Pugh.
Yes, Mr. Chairman, at the appropriate time, I move favorable with amendments.
Now's as good as any. Representative Pugh moves that House Bill 784 be reported as amended. Is there any objection? Hearing none, House Bill 784 is reported as amended.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman.
members.
Members.
Okay, sure. Okay. All right. Who's next?